Okay, so we're going to talk legal for caregivers. If you have questions, feel free to raise your hand. I'd be glad to take your questions as we go along. I want to make sure that you understand what we're talking about. We're going to cover powers of attorney for finances and medical decision-making and paying for long-term care with Medicaid. And you had an excellent presentation from Tam that was spot on as far as this is a terminal illness, and we are going to need long-term care at some point. And so we're going to talk about how do we pay for that, especially with Medicaid. Okay, but first, let's start with financial powers of attorney. So a financial power of attorney is just a piece of paper that says this person is appointed to handle my finances and make decisions for me if I cannot. Here in Texas, we have what's called a statutory durable power of attorney, and that just means that the legislature has set forth a form that they want to encourage people to use because they want third parties to feel more comfortable with that form. They want it to be familiar, and they want people to use that form, okay? So it's a statutory durable power of attorney. Durable means that it is good even when you're incapacitated, okay? So if you have a regular power of attorney that's not durable, that means that it's not effective upon incapacity. We always want to have a durable power of attorney. Another name for it is also a general power of attorney, and again, we want it to be durable. The most important thing for you to remember, what I want you to go home with is, we want to get that right away. We want to have that as soon as possible. Ideally, everyone in this room would have a financial power of attorney for themselves so that if something happened to you, there'd be someone who could handle your finances for you. How many of y'all do have your financial powers of attorney? A lot of y'all, great. Now, how many have financial power of attorney for the person you're caring for? A number of y'all, okay. For those of y'all who don't, you want to do it as soon as possible, because remember that the person has to have capacity, has to understand what they're doing in order to give power of attorney. And yes, ma'am.
What about if you did this already, but you did it in California?
Great question. So her question is, she did it in California, is it good here in Texas? If you can, I want you to do it again in Texas. I want you to use the forms from the state you're in if it's possible. Now, if the person has already lost capacity and all we have is what's from California, then that's what we're going to make do with, and we're going to do the best we can with what we've got. Okay, yes, ma'am. Okay, so she's talking about, can you do one thing after death to have someone who's appointed to handle the disposition of remains? And you can. There's a document called Appointment for Disposition of Remains, and that's an important document to have if your loved one wants to be cremated, because here in Texas, the default is that you're going to be buried. So if you want to be cremated, you want to have someone who is in charge of that. And that's the appointment of agent for disposition of remains. Yes, you can do that. Okay. Yes, ma'am.
When you have the statutory durable power of attorney, does that also include making the medical decisions?
Whoops. No. Because in Texas, we have two different documents. We have a medical power of attorney and a financial power of attorney. Some states may have it combined, but here in Texas, we have it separated. And the medical power of attorney is a separate document. Okay? So let's see, what do I say here? Oh, on your statutory durable power of attorney or your general power of attorney, you have the option of making it effective only upon incapacity or effective immediately upon signing. I strongly recommend that you make it effective immediately upon signing. That means that you really have to trust the person who you're appointing. And it doesn't mean that your rights as the person who's being cared for are taken away by giving someone else authority to act immediately, but it makes it much easier down the road for your caregiver to take care of things and manage business if it's effective immediately. That way they don't have to show to a third party like a bank that the power of attorney is effective by giving doctor's letter or something like that, that the person is incapacitated. So we want it to be effective immediately. We also want to name alternates. We don't just name a primary agent and no one else. We name a primary, an alternate, and even a second alternate to take care of business if something happens to the first agent. Okay, everybody with me? I like that Tam made y'all say yes. Yeah. Okay, everybody with me?
Carol,
Okay.
are you taking
Somebody said
questions?
no. Question, yes.
I was told by the bank, I have a financial power of attorney for my mom, but I was told by the bank that if she passed away, that my power of attorney is no longer good. So in order for me to take care of that situation, I had to put myself on her bank account because the power of attorney was voided after she passed away.
Okay, that's a great point. Your power of attorney, I can't get this where I want it. Your power of attorney is only effective while the person is alive. It expires when your loved one expires. That means that if you want to be able to pay bills after the person has died, one way you can manage that is to be on the bank account. Another way you can manage that is to have a small bank account that you're on. We don't usually want you to be a joint with right of survivorship owner on an account, because that means that automatically upon her death, it goes to you, and that may not be what her wishes are. She may want it to be shared with all of her children, but if there's enough, if there's a concern about being able to pay bills after death, then having a small account that you're on is a great way to handle that. Okay. All right. Yes, over there?
If you have a power of attorney and you also have, you're in the last will and testament, and you're willed over all her accounts, everything, the power of attorney, is there a difference between the power of attorney and the last will and testament?
Yes, there is a big difference between a will and a power of attorney. A will is only effective upon death, okay? So while someone is alive, it doesn't mean anything. The power of attorney is what gives you authority to act while the person is alive but incapacitated, okay? So let's see. I know that I'm speaking to the choir here, but for everyone who is thinking about getting power of attorney, remember that the agent that you name, or the agents that you name, must be trustworthy, okay? It can't be a situation where you think, well, he's my oldest kid, I'll name him, his drug conviction, that's not really important, okay? We want someone who is trustworthy. And you had a question, sir?
Yeah, the question concerns a living trust and how that would impact as far as managing assets.
Okay? For someone who has a living trust, what that means is they have their assets in a trust, and instead of having an agent under a power of attorney, they have a successor trustee named. So when they become incapacitated, or if they choose to resign because they feel that they can no longer serve, the successor trustee steps in. Okay? A living trust is a way of managing affairs, managing assets it's a different way than using the power of attorney, but it's the same concept where the successor trustee steps in and acts for the original trustee. Make sense? Yeah.
Paying bills and stuff too, with the living trust?
So when you utilize a living trust, the successor trustee can step in and pay bills as well.
With the
Yes.
living trust?
With a living trust, yes.
Okay.
Yes. Okay. So when you're looking at the financial power of attorney, the statutory durable form, it has some options to it. One of those options is a gifting power. Now, we're going to talk about Medicaid and planning for Medicaid. I strongly recommend that when we're doing powers of attorney, a financial power of attorney for a person who has the disease, and we know that long-term care is coming up, that we use a gifting power. And so I know I'm not giving you a lot of details, and you're probably thinking, what is this gifting power she's talking about? Let me just say that when you go to the lawyer to do your financial power of attorney for your loved one, or to do the financial power of attorney, you want to go to an elder law attorney who is familiar with the gifting power and will make sure that the power of attorney has sufficient powers in it for gifting. Did I hear a question? Yes, ma'am. No, that cannot be done retroactively. Once the power of attorney is done, if the person still has capacity, we could do a new power of attorney, but we cannot retroactively make changes to the existing power of attorney. Exactly. I'm talking about gifting money on the person's behalf. And that does have something to do with Medicaid. We're going to talk about it in a minute. Okay. Yes, ma'am.
Well, but who decides whether they have capacity or not? Is
All
that
right.
like a legal thing, or they have to be deemed legally incapable?
Well, that's a great question. You need to have capacity in order to do a power of attorney.
Right.
That can be just, you're presumed to have capacity until a court takes it away. So if you brought your mom and she is, or I went to visit your mom and she's bedbound and she's nonverbal, even though a court hasn't said she doesn't have capacity, I'm not going to do a power of attorney for her because I'm going to say, you know what, I don't think she understands what's going on. All right? On the other hand, if you came to me and said, okay, I need a power of attorney, I would say, oh, okay, here you go, sign it, and here we go. Now, in between that big, broad spectrum are a lot of different levels of capacity. I make the decision based on my gut whether I'm going to do a power of attorney for someone or not. If I think they don't understand what we're doing, then I say, no, we're not going to do it. They can always go down to another lawyer down the street or to a notary public or pull something offline, off the internet, and get somebody to notarize it for them. But ethically speaking, they need to understand what they're doing in order to do that power of attorney.
So it would still be legal if I believe my mom understands. Like, we've had all these papers done, but I'm seeing that probably some of these things we missed. And so now I'm thinking we need to update and revisit. And obviously, she's had a decline from the time we did it in the first to now. So I was wondering, can we take her and have them redone?
Sure.
She speaks well and often. So I mean, I was just wondering if we took her now, even knowing that she already has this, she has the dementia, she's declined, legally, we're good, as long as the attorney that we
It
take her to
depends.
says, as long as the attorney that we take her to says, I feel fine, sort of, and we would only be getting stuff that would benefit her, obviously. We're not going to be
Yes.
taking her to do anything other than that.
Yes.
I was just trying to figure
You
out the
could try.
legality of that.
Just having the diagnosis doesn't mean that, oh, no, you can't do a power of attorney now.
Okay,
So-
so we would be okay to take her to update
Yeah,
it, to make
try it
sure
and
that
see.
we have everything covered. Okay,
Try it and
thank you.
see. Yes, ma'am.
If you have a living trust and you have your assets, in a living trust, if you have your assets put into the trust and also some of your accounts, bank accounts put into the trust, but if you have some other bank accounts and you put a POD on it, is that acceptable?
Okay, the question is about if you have some assets in the living trust and some assets in a POD. It really depends on your estate plan. That's a little bit more complicated than what we're going to talk about today, but afterwards we can talk about it. Okay? So it's important to recognize that last line there, agent has a fiduciary duty to the principal. So that goes back to caution must be trustworthy. If you are the agent to your person who you're caring for, you have a fiduciary duty to act in their best interest, okay? You must be scrupulously honest regarding their affairs and act in their best interest, even if it's not in your best interest. So please keep that in mind as you're going about your business, that you have a fiduciary duty. Okay. There we go. The medical power of attorney, again, the principal needs to have capacity in order to give it. We want to have the principal have a conversation with the agent so that the agent knows what the principal's values are, so the principal can act, so the agent can act in accordance with the principal's wishes. And by principal, I mean the person giving the power of attorney. Agent is the person who is acting for the person who needs care, okay? Your medical power of attorney is effective only upon incapacity. So that means in this case only, when the physician states that the person can no longer understand what they're doing medically, then the medical agent can act for the principal. Yes, ma'am. Under medical directive is another word for directive to physicians, and a directive to physicians is a different document from a medical power of attorney. The directive to physicians is what a lot of people call a living will, and that just goes to what kind of treatment you want at end of life if you're terminal or in an irreversible condition, okay? The medical power of attorney is a broader document that authorizes someone to make medical decisions for you in all circumstances.
Because usually what they will ask you at a hospital or whatever, do you have a medical directive?
They oftentimes use an umbrella term called advance directives, and they'll say, do you have advance directives? And that includes the medical power of attorney and the directive to physicians. What you want to be sure and have is the medical power of attorney. Yes, ma'am. Here in Texas, it is the same thing as a healthcare proxy. Here in Texas, we usually call it the medical power of attorney. Yes, my recommendation is if you have documents from another state, if you can, go ahead and redo them here in Texas so that you have documents that are familiar to the providers here in Texas. Yes, ma'am.
When does it become necessary to seek guardianship?
That's a great question. If you don't have medical power of attorney or financial power of attorney, and the person is incapacitated, then we might not be able to act for them, and we need to be able to handle their business. So we have to go and get a guardianship. Guardianship means that we go to the court and we say to the court that the person is incapacitated and needs someone to be in charge of their business.
Can a family member seek guardianship even though there's a medical power of attorney already assigned?
The court is going to look for the least restrictive alternative, so they're going to want to go with the medical power of attorney unless for some reason it's not working, like the family is fighting and there's disagreement about what the best course of treatment is.
So in the interim, is the hospital or the staff obligated to refer to the medical power of attorney if the guardianship
yes.
is still in question?
Well, that's really a question for the legal department for the hospital. They're probably not going to want to do anything at all until a guardian is in place. Okay. How expensive is guardianship? Guardianship can be very expensive. You don't want to do it unless you absolutely have to. You want to have your powers of attorney in place instead. So guardianship, if we are doing a guardianship, we start with a retainer of $4,000 and then we try to go from there. Okay.
I've got a question over here.
Okay. I have a father who's definitely got
behind you so that I
dementia.
can
I
get
don't know what stage he's at. He hasn't seen a neurologist about it. He's in hospice. He's also an alcoholic, and he's got someone living in his home who's exploiting him financially. We've talked about guardianship, and he's agreeable to it. Because even being on his bank account and all that sort of thing, I can't, he's incurring all these overdraft fees because he's taking out money and not remembering it. So that would not be enough. If he said he wanted to give me guardianship, how would
No,
that look?
you
can't do that.
Yeah, guardianship means that a court has taken away his rights and given them to a guardian.
That would not be sufficient reason for the court to rule that.
What would not be
guardianship-
sufficient reason?
Just the fact that he's, like victimizing himself, or being exploited and
I
not being
think
able
the-
to make good financial decisions because he'll take out $100 one day and not remember and go do the same thing tomorrow.
I think the court is going to want to look at least restrictive alternatives and supports and services and not do a guardianship right away. Okay. Okay, just, if we don't have a medical power of attorney, the law says that the spouse can make medical decisions, and then adult child with the consent of the other adult children, the majority of the reasonably available adult children, and then it goes to parents and then nearest living relatives. So if we don't have a medical power of attorney, we do have some alternatives, we have some options if the person is incapacitated and we have to make medical decisions for them. But we do not have this same option for financial matters. We don't have an option that is not guardianship. Yes, ma'am. Well, is the person incapacitated? So you've got an incapacitated person with no medical power of attorney, and does that person have family members?
Yes, they do, but they're out of state.
Are they willing to be involved? Well, if it's emergency treatment, then of course the medical providers are going to provide emergency treatment. If it's stuff that has to wait, then as soon as they get back from the Bahamas, we call them. Well, if I were the medical provider, I wouldn't do it. It's really a medical provider decision. It's like, whose consent do you take? Well, I think it's up to the medical provider to determine whether it's an emergency or it can wait until the person is back from the Bahamas. Okay. Okay. Yes, sorry about that. It was actually a very particular question, so it's probably not useful to repeat it to everybody. I apologize. I should have repeated the question. But let's go on to paying for long-term care. So when we need long-term care, we can get that at home. We can get it in a personal care home, an assisted living facility, a nursing home, or even in a adult day facility. But how are we going to pay for that? We're not going to pay for that with Medicare. Okay, so for anyone who thinks that Medicare will pay for long-term custodial care, I want you to understand that it will not. Medicare will not pay for long-term care, okay? Medicaid will pay for long-term care. You can also pay for long-term care with long-term care insurance or out of your own pocket, a private pay. Medicaid, though, has some eligibility requirements. One of those is monthly income. Another one is resources like your checking account, your savings account, your house at the lake, the vehicles, that kind of thing. Medicaid also has a medical necessity requirement. Medical necessity means that you need the services of a licensed person. It's more than just needing assistance with the activities of daily living. It's needing a licensed person. So it's very important that you not get eligible for Medicaid financially and find that you do not meet medical necessity. Now, I want to talk a little bit about income. There is an income cap for Medicaid services of $2,313 gross monthly. That is not an obstacle to eligibility for nursing home care, however. Why? It's just an extra hoop we have to jump through. Never let someone say, oh, you're not going to qualify for Medicaid in the nursing home because you make too much money. It doesn't matter how much money you make, even though you're above the income cap, the $2,313, we just have to jump through some extra hoops in order to qualify you, okay? So there are some other Medicaid programs that also have an income cap that we can't get around. But for nursing home Medicaid, the income cap is never an obstacle. Can everybody repeat after me? The income cap is never an obstacle for nursing home Medicaid. Okay. Ooh, the power. Okay. We talked a minute ago about resources. Your homestead is an exempt resource. Your one vehicle of any value is an exempt resource. IRAs, if you're over 70 and a half and it's a traditional IRA, is an exempt resource. Other IRAs like Roths, or if you're under 70 and a half, we have to do some stuff in order to make it an exempt resource, but you can still keep it in mind as, okay, IRAs are exempt. Countable resources are things like bank accounts, your investments, extra vehicles, as I said. Certain annuities are countable resources. Your mineral interests are countable resources. The ranch that you inherited from your grandmother, that's a countable resource. Okay, now we're going to get a little bit complicated, and I don't want to get too far into the weeds here. What I want you to understand is that Medicaid eligibility is complicated, but there are things that we can do to enhance or accelerate eligibility for someone, okay? If you're an unmarried person, your Medicaid resource limit is $2,000. By that I mean $2,000 in countable resources, $2,000 in your checking account, $2,000 total checking, savings, Merrill Lynch, etc. $2,000. Okay? Everybody with me? All right. If you're a couple, if you're married, it's different. Medicaid wants to keep the spouse at home from becoming impoverished. And so they say, spouse at home, you get to keep more money than just the $2,000. And what they do is take all the countable resources and they put it in a pot. And then they cut that pot in half. And they say, spouse at home, you get to keep your 1/2 up to a certain limit. Just their half up to a certain limit. So if you've got $400,000 and you cut it in half, spouse at home doesn't get to keep $200,000 because her limit is only $126,420. She keeps that $126,000. He keeps $2,000. And then we've got all the rest that we have to do something with. Okay, now. No, he keeps $2,000. Remember, the Medicaid recipient keeps $2,000. The spouse at home keeps 1/2 up to the limit of 126. And then we have all the rest that we've got to do something with. I'm not going to tell you all the things we can do with it. I'd be glad to tell you, but I don't want to get y'all all glazed over and saying, oh my gosh, she's the last speaker of the day and she's killing us. I'm just going to tell you there are things that we can do. Okay? Now, here's where that gifting becomes so important. Let's say we've got husband and wife, and husband has gone into the nursing home and wife is at home. We want to be able to give all of the assets that husband owned to wife. Okay? Because remember, husband can only own $2,000. So we've got to get the rest of it away from him, out of his name. And we want to have authority to do that in the power of attorney. We want to have authority to give husband's share of the house to wife so that we can avoid estate recovery. Now, I don't have a slide on estate recovery, but I just want to tell you, when we go into the nursing home on Medicaid, Medicaid says you get to keep the house and we'll still pay for your care. But upon your death, we want your heirs to sell the house, pay us back, and then get whatever's left over. The heirs get whatever's left over. That's called estate recovery. We can avoid estate recovery if dad doesn't own the house upon his death. Okay? Now, we also have exceptions to estate recovery. So don't think, oh my gosh, my husband dies, I put him in the nursing home on Medicaid, he dies, and they're going to come take my house from me. No, there is a surviving spouse exception. That means that if there is a wife or spouse who is living at the time of the nursing home spouse's death, there's no estate recovery. Okay? Y'all with me so far? Yeah. Okay. But if wife dies first and then spouse in the nursing home dies, we would have estate recovery unless we had given his share of the house to spouse and it passed at her death by her will to her children or to a trust for his benefit or something like that. Okay? So, Gifting is hugely important in Medicaid planning, and we want unlimited gifting, okay? Hang on just a sec. The statutory durable power of attorney has limited gifting. So we don't want to just use that document. We need to modify that document to allow gifting, unlimited gifting to the agent. Okay, yes, ma'am.
But does the 126,000 still apply?
The house is exempt, so if we give his share of the house to her, it's still exempt.
It's still exempt.
It's still
It's
exempt.
not part of the
It's
126,000.
not part of the 126,000.
Okay.
Now, one thing to keep in mind when you're talking about gifting, gifts between spouses are not penalized by Medicaid. But if we took his share of the house and we gave it to his kids, then we would have a penalty period. We would have a period of ineligibility. So we don't just give willy-nilly. We give with a strategy in mind. And it could be that we go ahead and give his share of the house to the kids or give some of that money to the kids. We have ways, we have techniques that we can use to make gifts and still accelerate Medicaid eligibility. Their strategies, their loopholes, you know what lawyers do, come on, right? Okay.
We've got another question over here.
Yes.
So I think you might have answered part of the question, but I was going to ask for the single person what, the advantages of gifting, the gifting part. That doesn't
Okay, so the question is about the advantages of gifting for the single person. We still may want to make gifts. For example, if we have children who we trust, we may want to give part of our estate to those kids to hold for our benefit, to use that money for our benefit while we're on Medicaid, because when you're on Medicaid, you're paying your share of the income to the nursing home, and then you're keeping $60 a month for your personal needs. So we could have some extra money for personal needs. We use a technique called, there's a technique that we use that provides for paying the nursing home while we're in the penalty period with part of the estate and making a gift of another part of the estate. Make sense? Not really? Okay. Okay. So, yes, ma'am.
Wait, can you just hold on one second so that everyone hears your question? Thank you.
My father currently qualifies for Medicaid. We're hoping to have him move in with us, and he has a home. If he sold that home, we have no place to put him but our dining room right now. How can that work where we would have the money to add a room to our home for him?
Okay.
And him not be penalized and not qualify for Medicaid anymore?
Well, that's actually a very complicated issue, and so we can talk about it later, but it could be that we don't have any good options there. Okay.
We're going to take one more question, and so we'll let Carol move on.
If personal property is placed in a trust prior to applying for the Medicaid, does that protect that?
Personal property or any property placed into a trust doesn't protect it for Medicaid purposes. So if you put it in a living trust, it's still countable. And if you put it in an irrevocable trust for the benefit of someone else, then there's a transfer penalty.
Oh, okay, thank you.
So, but in general, personal property doesn't really count for much. So for Medicaid purposes, unless you're talking about maybe you've got a Picasso or a really expensive tractor, I don't know. It's not going to affect your Medicaid eligibility.
What if it's land?
Okay, just remember that land is not personal property, land is real property.
Okay.
Okay? Placing property in a trust is, there are some considerations, but if you're trying to preserve land that is not the homestead, you're probably, and you're a single person or a married person?
Widowed.
So it's a single person.
Yeah. It was
There are,
family property, though, that had been passed down.
yeah, there are not a lot of options, but there is some planning that we could try. We would have to know the particular circumstances.
Okay, thank you.
Okay. Here we go. Find an elder law attorney. If you are going to need Medicaid planning, you want an elder law attorney, and you want to find them at the National Academy of Elder Law Attorneys website, and that's the address right there. You don't want an attorney who says they do elder law along with criminal law, bankruptcy, wills, and probate, okay? That's not an elder law attorney. An elder law attorney is someone who specializes in this area and knows it deep and wide, okay? You don't want someone who dabbles, because it's very important. It's a complicated area, and you need someone who has sufficient expertise. And that was the last slide. Okay. Thank you.